You know how saying, "I'm gonna hit you," will land you in handcuffs? Well, what if I told you that saying, "If you don't stop bothering me, I'll hit you," might actually get you in less trouble or maybe way more trouble, depending on where you live. Welcome to the absolutely bonkers world of conditional threats. Let me paint you a picture. You're being harassed. Maybe an ex won't leave you alone. Maybe someone's stalking your family. You've had enough. So you say, "If you don't back off, there's going to be a problem." Boom. You just made what lawyers call a conditional threat. Now here's where your brain should start hurting. In some states, that conditional "if" actually makes it better for you legally. Why? Because you gave them an out. You gave them a choice. Courts see it as negotiation rather than pure intimidation. It's like the difference between an ultimatum and a death sentence. But here's the plot twist that defense attorneys whisper about in back rooms. Prosecutors absolutely hate conditional threats. Not because they're worse, but because they're harder to prosecute. Intent becomes murky when there's a condition attached to it. So what do ambitious prosecutors do? They get creative. They pile on additional charges: harassment, stalking, intimidation, whatever will stick. I've seen cases where someone said, "If you keep coming to my house, I'll call the police," and got charged with making threats. Think about that for a second. Threatening to call the police on someone who's trespassing. The First Amendment actually protects certain conditional threats. Courts have ruled statements like, "If politicians keep ignoring us, there will be consequences at the ballot." Even though there's technically a conditional threat, but try explaining constitutional law to a prosecutor who wants to make their career on your case. Good luck with that.